Kia ora everyone, how are you? Thanks for coming to the our session, which is legal. Usually boring, but we'll make it really interesting for you guys because we love gaming. So I'm Ed, and let's get to the next slide. So we're going to start a new game. It's a legal game, and it's Who Are We? So we're glad to be one of the sponsors here. So we're from Hudson Gavin Martin. We're a technology, media and IP law firm. So we help a lot of technology startups, scale-ups, right through to your global tech companies to protect your IP and commercialise. So we've got a lot of gaming clients. We do a lot of work for Legend Story Studios. Calvin and I have been playing for the last hour or so, trying to learn how to play the game. And we do a lot of work for the likes of Unity. So we helped Unity purchase the assets of Weta Digital a couple of years ago. So we do a lot of that work from a commercial, corporate, IP, and hopefully you'll never need to use the litigation team that we have. So a bit about me. I've been playing games for probably too long. I could say that when I started working, that kind of stopped, but I'm so glad that I have two young girls, they're 8 and 10, who just love playing PlayStation and on the iPads. So don't judge me for giving them too much screen time, but they can pretty much beat me in everything. That's what I still own in blue. I still got my PC, Nintendo Switch, or my girls have, PS2, 3, 4, 5. My wife thinks I hoard too many things, but I just love them. And yeah, I've got all of the PSVR 1s and 2s. And then I bought myself an arcade machine with 2,000 games on it. So that's me. And Calvin?
Hi, I'm Calvin. I work with Ed. I'm in the corporate team at HGM. So I do all the shareholders agreements, sales and purchases, company structures, stuff like that. And as you can see, up on top, we have the first 2 bullet points on my name are 2 very life-draining series, Monster Hunter and Super Smash. And to top it off, I have a 3rd very life-draining hobby, in terms of time, I mean. Very fun, but it's a wonder how I find enough time for actual work.
Is that why you're not working? So today we're just going to... There's a lot of information on these slides, and so the idea is that if you guys want a copy of these slides, just flick us an email and we'll either email them to you, and we'll try and cover as much as we can and then take some questions at the end. But I thought for this session what we will talk about are some of the legal issues that affect your actual business when you're setting it up, getting your shareholders in, all that sort of stuff. And then the second part is all around legal issues that actually relate to the game itself. So in terms of the first part, the legal issues relating to your business, we're going to talk about setting up your company and what's involved in that, and like shareholders agreements, constitutions, all that sort of stuff. The second part of that will be around understanding what IP is, because that is the core asset that you have as a game studio. And setting up a structure to protect your IP will be the third part of part 1. So you're wondering who actually really cares about legal, right? Well, everyone should care about it because we see things from an investor's perspective as well as a purchaser's perspective. So all of these gaming companies and tech companies that are selling for a lot of money will have due diligence done on them by the purchaser. And so when we're acting for the purchaser, we will be looking at all sorts of things around, how is your company structured, who owns the IP. And so you should sort of care about how your business is run, and so that your house is in order for when this is all ready to happen. And like I said before, it's your business's IP, so you should be trying to protect from day one. Your customers care because they want to know that you have the right contracts in place, that there is protection for them if your game doesn't work. Can they get refunds? Will you fix bugs in your game or whatever it might be? As I mentioned before, there will be investors, shareholders and potential purchasers who you'll try and get on board. They'll be looking at the stuff that I've just talked about, how have you set things up? And also the authorities care about how you're running your games. For example, what information are you collecting from your users, especially if they're children. So the Office of the Privacy Commissioner, they might be knocking on your door. You've got the Commerce Commission, who will be looking at things like consumer and fair trading issues. And I do a lot of work for online gambling companies, and so the Department of Internal Affairs will be likely quite interested, because you're not allowed to have online gaming services here in New Zealand. But if you're overseas, you'll find you're just not supposed to market them. So I'm just going to hand over to Calvin, who's going to talk about setting up a company.
Right, thanks, Ed. Setting up a company. So company is just the most common structure for these kinds of things. Very versatile, very useful. As you can see, there's a lot of pros to this setup. Essentially, because I guess the setup itself is just really simple. You go in the company's office, pay a few $100s, and maybe after a few hours, after you fill out all the forms, you'll be a company director and or shareholder. The upkeep is, to be honest, quite minimal. Just file your annual returns, make sure you have a share register. In terms of having being investable, the main kind of advantage of a company is that you don't need to sell all your assets individually when you eventually sell up, if that is the goal. It's easy for investors to kind of invest in your vehicle, because all they need to do is have shares in the company. If you own all the shares of the company, then you basically own everything that the company owns. It's a simple concept that allows investors to come in for whatever percentage they want, and they don't need to own, certain assets of the company and not others. And the relevant act there, if you want to take a look afterwards, is the Companies Act. Very important when you're to know your obligations under that act if you are setting up your own company. I'm just going to go through the basics of what setting up a company entails. To be honest, the slides contain way too much information, so I'm just going to fly through. It's not intended that you will be know every meticulous detail, how to set up a company, get an investment, etc. After this, but it's just to get you familiar with kind of the terms that you'll encounter, the kind of concepts that you'll encounter when you set up a company, raise capital, and so on. So when you set up a company, it's recommended that you have a document called a constitution. What the constitution does is that it sets out the ground rules for your company, and these ground rules, all shareholders will have to kind of abide by them. One advantage of having a constitution is that there are certain powers in the Companies Act, certain things that you can't do unless you actually say that the company can do in your constitution. For example, one example is getting insurance for your directors. So if you don't have that in your constitution, you just can't do it. So, but having said that, constitution isn't mandatory. Usually you would get your lawyers to draft one up, but I believe there are also some various templates online floating about. It's not a complex document, but it's important to, I guess, read through and understand what your obligations are under a constitution, if you have one. So the second most common document relating to companies that we encounter is the shareholders agreement. So a constitution is a public document that you register with the company's office once you when you have a company. But a shareholders agreement is somewhat different. It's a private document, it's a private contract between you and any other shareholders. So if you are the only shareholder in your company, you won't have one of these, because I'm sure you'll agree with yourself all the time. This document is so that if you don't agree with one of your fellow shareholders,
it sets out the rules for what happens. And yeah, as it says on there, it complements the Constitution, and everyone basically at the beginning, when they get their shares, or when they get their shares, they agree to be bound by this shareholders agreement. These are some of the things that you might want to address in your shareholders agreement, just common things that, common topics which require some agreement between shareholders, like what happens when you want to issue new shares, what happens when you want to transfer shares. Preemptive rights means before issuing or transferring shares, that those shares have to be offered to existing shareholders first. That's before anyone else can buy them, so that's what the preemptive part means. There are things like tags and drags. What happens when an 80% shareholder sells to a buyer, but the buyer doesn't want 80%, they want 100% of the company, otherwise they're not buying. Well, a drag along right will allow you to force that 20% shareholder to sell. So these kinds of concepts are kind of the ideas that you want to discuss with your fellow shareholders once you kind of get that company together, or once they come on board. And to kind of go into that, we'll go into the kind of common issues between shareholders. So when you want to bring in, let's say you and a buddy have a company, maybe you own it 50-50, and you put all your IP and assets into that company, that's your business. You want to bring in a new investor, well, what happens? You want to issue shares to the new investor, well, then the default preemptive rights under the Companies Act, i.e., if you want to issue shares to a new investor, you have to offer those shares to existing shareholders first. That's just to kind of give them the first right to purchase those shares before the investor does. That in some cases can be a hurdle to bringing in investment, because if you are only willing to say issue up to 30% of the company in new shares, but your buddy wants to take up like 15%, well, the new investor won't get the entire 30% that they want. So you kind of need to discuss the share issues with your fellow shareholders first, or agree a rule as to how they may be issued in the shareholders agreement. So that's one common aspect that's addressed in the shareholders agreement. There's also raising capital. When you raise capital, do you want to go to do you want the company to raise only from shareholders first, or will you allow bank lending? What do you want to do in terms of shareholders personally guaranteeing the company's obligations? And if your buddy wants to sell out of the company, what happens? Does he or she have to kind of offer their shares to you first, or can they, if they sell to have a buyer in mind, can they force you to sell your shares along with theirs? Those are the kind of issues that we often see negotiated in a shareholders agreement. And other kind of clauses that are relevant in the shareholders agreement include a non-compete. Usually we see in shareholders agreements that the shareholders can't compete with the business of the company for as long as they're shareholders, and usually for 12 months after they start being shareholders, which I guess commercially just kind of makes sense. If they're working with you on a developing IP or a game, you don't want them to be developing a competing kind of business at the same time, using the knowledge that they have of the inner workings of your business. So that's just in a very tiny nutshell, kind of the kind of ideas that you want to consider when you are joining hands with other shareholders and creating your own company for your business. But in terms of why you made the company in the first place, it's probably because you want to be able to raise cash easily. So here's some of the concepts that we often see in when we deal with cap raising. So usually people see cap raises in rounds. This is not any kind of formal thing. It's more of just knowing which round you're in kind of gives an understanding of what expectations are required of you. Let's just say you just got an idea, maybe you haven't even got your company started up yet, and you're about to, or maybe you just incorporated your company, and you need some cash basically to get things going. Maybe even like 5-10K would be great at that stage. At that stage, is the pre-seed, or what we call the family and friends round, because that's who you'll be borrowing money from most likely. Often we see that these are quite informal raises for small amounts of cash to kind of get the company off the ground, but practically it's kind of hard to engage any professional help at this point, just because if you want someone to draft a document for you to raise 5K, the document itself will probably cost half that. So and it's from friends and family, so that people are often comfortable with just have an oral agreement, or maybe none at all. But in the seed round is kind of when you kind of get your first formal third-party funding. And from this round, when you get third-party funding, there's the investors will want their investment to be protected. So they will do due diligence on your company, and they will expect there's certain protections in the agreement that you hand them regarding their investment. They'll often want shares in your company, and they'll want you to give them certain warranties around those shares, and maybe certain special preferred terms. Beyond seed, Series A, B, and C is much of the same thing. You're getting investment from sophisticated third parties, probably for large amounts at that point, because your company would probably be quite mature. How to start a cap raise? Well, the very first, I think you look within, because you already know some investors, and those investors are your shareholders. So approaching them and seeing whether they have any cash to inject into the company is probably the first step most people take. And then seeking external funding after that is just, what happens if the shareholders put their hands up and say, well, no, I got no cash. So the second point there is that is a point of caution actually, is that while more investors means that potentially you get to raise more cash, if you have, say, 20 plus shareholders and they all hold like 3% or whatever each, then it becomes administratively quite difficult to get stuff done, just because every time you need a resolution from your shareholders, you need to approach so many people, and so many people have a say because they have voting shares presumably in what happens or the direction of your company. So I guess the preference for a lot of companies is to get one big investor to kind of inject the cash that they need, if possible. In terms of getting a valuation, that's something that's outside my wheelhouse, but it's important if you are getting third-party investment. There are a lot of firms out there that do that kind of stuff, but it's at the end of the day, it's really about how much you can sell your company. That's what really determines the price that they pay for your shares. Initiating a cap raise. So yeah, once you have all of that done, you can start. You can prepare basically a term sheet, a key, basically just jot down a list of the key terms, price, how much of the company they want, and how long it will take to get the deal done. and then they can start their due diligence, which is basically, if you've ever purchased a business or say a house before, then you'll know that part of the purchase process, which is just going into the company and going into its files and seeing, well, is this company legit? What kind of hidden traps are there that I'm not seeing before I make this investment? Another thing to consider is bridging finance. Don't leave your cap raise to the last minute. Make sure you have enough cash for you to kind of operate until the money comes in, because a cap raise is often not fast. I've seen ones that have gone on for months before they've seen a dime, and all that time you're incurring lawyers' fees, accountants' fees, etc. Stuff that investors may ask for. So these are terms that I've seen in investment documents. Investors often ask for these kind of things. One is a liquidation preference, which is that they would want their shares. They would want their shares to be the first ones to be cashed out in the liquidation, and usually for them to be guaranteed their initial investment or more. So let's say they want a 1.5 times liquidation preference. That means they get cashed out first, and they get cash or assets equal to 1.5 times their initial investment before anyone gets anything else. So, I mean, these terms have been asked, but of course it's up to you and the amount they're investing, whether you actually give them. You don't always have to. This is a matter of negotiation between you and investors. Special veto or voting rights. Maybe they want, if you're wanting to divest the IP, that's the one thing that they will have the ability to veto, despite them maybe holding only 15% of the company. Board seats, they might want a director on your board of directors. Usually we don't see these given to investors unless they invest at least 20% of the shares of the company, or get at least 20% of the shares in the company, just because if you think about, if you give directors at 10%, then you'll end up with a board of 10 directors, which is extremely unwieldy. Anti-dilution clauses. So this is a common concept that appears in investment documents. Basically, what it is that if they after their investment, if in a subsequent investment you issue shares at a lower price, they will not be very happy about that. So what they want is that when you issue shares at the lower price, you need to issue them extra shares to top them up, so that will be as if their original investment had bought shares at the lower price. That's essentially what it means. It's a way of protecting their value in case the company doesn't do as well as they initially thought. You can Google the various formulas that are used for it, such as the broad-based weighted average, which basically does what I just said. If you issue shares for a lower price, you've got to give them extra shares to top them up, to kind of buoy their investment. There are also various arrangements by which you can kind of they can inject money into the company. It doesn't necessarily just have to be a purchase of shares. There can be convertible notes, and what a convertible note is that they will lend money to the company, and you will have to pay it back at a certain time. But they also have the option of turning that loan into shares, depending on either at their option or on a trigger of a certain event. So there's a bit of flexibility into how the investors will inject money into the company, and it's really, I think, if you have an idea of how the investor would like to kind of fund the company, and it's not a straight purchase of shares, have a talk with your lawyers, and they can probably just draft something up. It will probably be an arrangement that we've seen before. One final thing in terms of issuing shares to investors. is to be aware that it's issuing shares is a regulated process in New Zealand. You can't just do it anytime you want to anyone you want for whatever you want. You have to follow the rules up there, which is the Financial Markets Conduct Act. This act basically ensures that companies which are worth not very much at all can't just issue shares and claim that they are going to do big things to normal mom and pop investors and scam them out of a lot of money. So that's what that act is for, is to ensure that whoever you issue shares to knows what they're getting into, and or they're a sophisticated investor. And the Companies Act, which governs companies generally, but if you want to issue shares, there'll be a few processes to follow under that act, including drafting resolutions, which you can ask your legal counsel to do. As for a couple of final notes on this section, in terms of the number of shareholders, as I mentioned before, more investors may equal more money, but it also means more people to ask for consent from when you want to do certain things. And sometimes you require maybe like 75% of the shareholders to do an action, or maybe 90%. So that's a lot of people to kind of get signatures from, and it's every time you want to do something. So keep that in mind. And some shareholders, especially if they hold 1 or 2%, just tend to not be very responsive at all, and that can also cause issues. Notable numbers of shareholders: when you reach 10 shareholders and 50 shareholders, extra obligations will apply to you. So ask your lawyers for methods of how to keep your shareholders under those numbers. They should be able to find something that accommodates you. Although it's not fatal if you kind of reach those numbers of shareholders, but it will be somewhat unwieldy, and you will have additional obligations in relation to your shareholders. So that was a very quick fly through, and hopefully you've kind of grabbed some of the concepts that you'll be encountering through setting up company, agreeing your shareholders agreement, and raising capital. Hopefully some of those concepts can stick, so you won't, when you are raising capital next time, it won't, and the concept I talked about comes up, it won't be completely unfamiliar. But yeah, after that I'll hand over to Ed to talk about IP.
Thanks, Calvin. So we've just talked about company structures. Obviously, there are different other legal structures like partnerships and things like that, but companies are probably the most common one that you'd be entering into or forming. So talking about IP is really important because this is the core asset that you have. So I'm quickly going to go through what we call unregistered and registered rights. So an unregistered right simply means that you have this protection automatically without having to actually do anything. So you don't have to go to like a website and register that you own the copyright or the trademark or whatever it might be. So unregistered rights include copyright or confidential information, and registered rights can include trademarks and patents. But today I'm just going to talk about the most common types of IP that you will have as a game studio. First of all, copyright. So copyright is a form of intellectual property that protects your literary, dramatic, musical and artistic works. So the literary part of it will be your computer source code, for example, because that's literary work, but it also covers off your any like the actual text within your game, anything relating to sort of literary works. So it does cover a broad range of creativity, like writing, software, drawings, films, like even clothing designs, photos, 3D objects. So it covers a lot of stuff. The requirements to have something that is that you can have copyright in, first of all, it's got to be original, and there's very low threshold, right? As long as you haven't copied it, then that's okay. It just as long as it's not infringing, so you can't have just copied it from somewhere else. It's also not merit-based, so it could be really bad. Like for me, I can't draw, but I could just draw a stick figure and I'd probably have copyright in that automatically, so that would stop anyone in this room from, well, copying my stick figure, not that you would. And it also protects the expression of the idea, not the idea itself. So everyone in this room could have the same idea. Copyright doesn't protect that. But when you take that idea and you put it into your, you code something and you create your game, then it's the expression of that idea that is protected by copyright automatically under the copyright here in New Zealand. So the value of copyright is that once you've got it, it stops anybody else from copying it, issuing it, or distributing that product. And the owner of the copyright can sue for damages. So if you have created a game and then you find it on the App Store and it happens to be strikingly similar to yours and you feel like they have copied it, then you can take action against them for breach of copyright. And we've had a number of gaming companies that have found that their game has ended up on the App Store somewhere which is very similar, and so we've been able to get the App Store to take it down. So the owner of copyright is the person who creates it. So essentially, if it's an employee, then the employer is the owner of the copyright. But if you're getting contractors in to help you develop your game, then usually this would be a commissioned work if it's like, say, software code, in which case the commissioner is the owner, so whoever's asked them to do that work. So, as I said before, the copyright is automatic. You don't have to register. It's free. We all like that, free. And it lasts a long time. So it's life of the author plus 50 years. So you can't do anything, or no one can actually copy it for the life of you plus 50. One of the cons is that you have to prove ownership and originality, and you have to keep records to show that you actually developed the thing. So that's copyright in a nutshell. So a lot of you will have copyright in the assets that you have created. The next important type of IP right is trademarks, because that protects your brand identity. And so a trademark essentially is a word, a picture, a logo, or a sound, and it can be, it has to be distinctive, and it can't be something that is descriptive of your game. So if you have trademark protection, what it means is that you can stop others from using a similar sign or logo on your goods. So here are some examples of trademarks. Like the game Fortnite is a trademarked word. So if I try to, if I develop a game and I call it Fortnite, N-I-G-H-T, I wouldn't be able to get that here in New Zealand or wherever I've registered that mark. The PlayStation logo, that's the device, so that's the actual logo itself. If you try and use that mark, you're going to have Sony breathing down your neck saying, "What are you guys doing? You can't do this." You've got shapes like the Coke bottle, colours like Cadbury purple, sounds like the Star Wars lightsaber sound, and you can even trademark smells. And the idea with trademarks is that they're indefinite, so as long as you pay the registration fees, you can have them for as long as you like, and it's a powerful marketing tool. The cons is that, or the drawbacks is that it's territorial, so that you have to get a trademark in the jurisdiction in which you want to protect it. So a lot of our clients want to publish their games in, or have their games available in the US, the States, Asia Pac. So you've basically just got to go everywhere to do that. But it's relatively, it's a really important thing to have, especially if it's, say, the name of your game studio. So those are two types of intellectual property rights that you will have as a game studio, and I'm just going to quickly go through in part C and IP corporate structuring. So we've talked about setting up your company, but what a lot of companies do is they will set up a company which there owns the IP. So that one company that you set up owns all of the IP and everything that you've created. So the copyright, the trademarks, the domain names, anything that you have is sitting in there, But this company here doesn't do anything in terms of licensing to customers or entering into contracts with anyone like employees or contractors. Because what happens is if there is a claim against this company, then that could take this entire company down and your assets are gone, right? So what people do is they set up an IPO-ing company and then employ people under one of their trading companies here. So if you've got a personal grievance or you have a customer claim or whatever it might be, then it's the company down here that is at risk. But, you know, fold that company and you've still got this company here and all of these companies operating elsewhere. So that's something very simple to do that you might want to consider. So, got to get to the next level, which is this one. We've just talked about your company's setup, and we've talked about the IP that you own. Now it's how do you commercialize the game? How do you develop it? So I'm just going to quickly cover what we see in terms of developing the game, licensing the game, the use of user-generated content and real-time chat, and also complying with laws. So first of, when you're developing the game, you've got to consider what is the platform or the engine that you're using. So this is the agreement between the platform owner or operators such as Steam or the Apple App Store or Google Play, and in relation to the engine provider, it could be Steam, Unity, or Unreal. So you'll be using all of these different services, and they'll have contracts with you. What you want to do is you want to read those terms and conditions to make sure that you can, first of all, comply with them, and if there are any specific terms that need to sort of flow through into your terms, then you need to make sure that you do that. In terms of the game development agreement, so this is where you might get a third party to help you to develop assets for your game or the actual game itself. It's really important to have that agreement in place with them, because the first thing that anyone will be looking at in terms of an investor or a purchaser will be who owns it. So we've got to make sure that there is an agreement there saying that whatever you've got a game, someone to create your game, you've got to make sure that all of the IP that they've created is assigned or shifted over to you as the owner, because otherwise you don't own the IP in the game. The agreement that you've got with the developer will also talk about, how do you test the game and how will they fix it, and there'll be certain warranties in there, for example, that the code that they've used hasn't been ripped off from another one of their clients, which is really important. The next thing is around the use of generative AI, because that's a really big issue at the moment with Gen AI in terms of creating code. Everyone's using it now, but there are huge risks with that. That's not to say you can't use it or shouldn't use it. It's just making sure that you are aware of what the risks are. For example, do you actually own the output that is created through Gen AI? If you are trying to create a character for your game, and you use a Gen AI tool to, Midjourney or something to create that, do you know where that output has come from? Are you actually infringing somebody else's IP? And can you guarantee the accuracy or the quality of the output that you're creating? And also, are there any confidentiality or privacy issues from the use of that generative AI? So when you put stuff into the Gen AI, you're feeding the large language models. Do you actually, can you actually put that information into the LLMs? The next thing is around the use of APIs. If you are using APIs, it's really important to check the terms and conditions of that as well. Like, do you have a one-way integration or a two-way integration? What kind of access does it have, like read-write access? Also, if you're integrating with social media platforms, look at their terms and conditions in terms of how you can link to their game. So that, we just talked about developing the game, and now you've got the game, how do you actually license it, right? So this is another really important part, which is the commercialization part. So first of all, games are licensed, they're not sold to end users. So when you've got a game and you put it on Steam and someone buys it, it doesn't mean that they own the game, right? They own, they don't own anything. Like when you go to, if you've got a game on that you buy, on DVD or like on your Switch, right? You might own the media that it comes on, but you don't actually own the IP or the game itself. So you need to ensure that you've got an appropriate end-user license agreement in place, and that's an agreement between the user or the gamer and you. And this is something that they enter into prior to download or installation. So the user agreement basically addresses things like, how they can use it, what they can do with it, can they use it for, multiplayer purposes and all that sort of stuff. Back in the day when, I shouldn't say this, but when I was a kid, I used to copy games all the time because I had an Amiga and that's what you did. I didn't know I was going to be a lawyer then. But I wasn't reading any end-user license agreements, but that's what an end-user license agreement basically prohibits you from doing. And again, it also has things around warranties and liabilities. So if something goes wrong with the game that you've, if you've provided a game to someone and it's really buggy and it's not working, all that kind of stuff, you don't want them turning around and trying to sue you for like megabucks, right? And so an end-user license agreement will have a clause in there saying that, hey, look, if all turns to custard, then the maximum that you can sue us for is maybe the value of the subscription fee, or the cost that cost for purchasing the software. The EULA should also include additional terms such as if you're interacting with online services such as Facebook, you might need to sort of incorporate their terms in there. If it's collecting personal information from people, then you'll probably need to have a privacy policy setting out how the information is being collected. But also, as I mentioned before, certain platforms and engine providers will require you to put certain terms into your contract. Like if you're uploading something to the Apple App Store, it will usually require you to put in certain terms saying, Apple's not responsible if X, Y, and Z happens. And the last part on this slide is around contracting with minors. So when you're dealing, a lot of games are obviously played by minors, and so we're talking about people under 18. In New Zealand, you can't contract generally with anyone under 18, right? So it's not enforceable. A contract's not enforceable against anyone under 18, but the under 18-year-old or the minor can enforce the contract against you. Okay, so it's just something that you need to be aware of. The next section is just around the use and monitoring of real-time chat and user-generated content, because a lot of games have that. So if you're using in-game monitoring and moderation of real-time chat within your platform, the best practice is to seek consent from the user for doing this, because there are laws here in New Zealand and around the world which prohibit but basically interception of communications, right? So under the Telecommunications Act, for example, there are provisions there which mean that you can't sort of intercept communications. And so we've had a look at this issue for a lot of the AAA companies who are sort of using real-time chat. And so I suppose the advice that we've given them is just seek the consent of the gamer, so that they know that they're, that their chat could be monitored or is being monitored. And also ensure that your terms, so the game terms or the end-user license agreement, allows you to suspend access to your game. So if someone is doing something really dodgy or saying horrible stuff or whatever it might be, you need to be able to kind of just boot that person off the server. In terms of user-generated content, so this is where you have people commenting or sending chat to each other. You should have in your terms and conditions something that says that they're not going to upload content which is defamatory or misleading, inaccurate, stuff that might bully someone or harass someone. Okay, so all those sorts of things should be covered off in terms of how people provide user-generated content. And the other thing is, the second point is anything that they upload shouldn't infringe the intellectual property rights of any third party. And then finally, compliance with the law. So a lot of the times when we have gaming companies come to us, usually it's like the game studios from, say, the US or the UK who'd come to us and say, look, we've got this game, we want to offer it in New Zealand. Are there any specific laws that we need to comply with? So we basically go through what might be relevant to them. So some of these will be things like the Fair Trading Act here. So the Fair Trading Act essentially means that you can't mislead or deceive people when you're marketing your game. So if you're saying, if you like have a game and it's got a whole lot of in-app purchases, but you actually can't actually use the game without actually purchasing something, that could be actually misleading or deceptive, because you're making someone download the game thinking that it's free for some parts, but if you're not offering anything for free, then that could be an issue. You've got the Consumer Guarantees Act, and so this essentially means that if you buy a game, so if I buy a game from EB Games and it's not working because, I don't know, there's something wrong with the way that's been put on the disc, if I'm buying a PS5 game or whatever it might be, then I need to be able to go back to the store and get my money back or get a repair. So that's what the Consumer Guarantees Act says. If someone downloads it from Steam and it doesn't work on their PC, then you can't say, well, we're not going to give you your money back. You need to be able to provide the user with a remedy. You've got the Privacy Act that you need to comply with when you're collecting information. You need to tell people, I'm collecting information from you. This is what I'm using it for. These are the people I'm giving it to. So you need to provide that disclosure. You also have the Unsolicited Electronic Messages Act, which is a real mouthful. That's basically the Spam Act. So if you're trying to collect, if you collect people's email addresses and try and spam people by saying, hey guys, we've got this new release of a game and it's coming out now, you can't actually do that unless you have that person's consent. So don't go buying a whole lot of databases with customer details and try and email them, because you just can't do that. As I mentioned before, if you've got like any form of online or gambling, that's something covered by the Gambling Act 2003, which is basically you can't have a platform like that unless it's licensed, and only Lotto New Zealand, I don't think TAB have that kind of license. Harmful Digital Communications Act, that's really important. If you're running a platform and somebody is sending harmful messages to another user, or they're being bullying behaviour, all that sort of stuff, you might get a request for a takedown, as in you've got to take that user down or take that post down. So as a gaming platform or studio, you've got to take that down. And then the last one here, I've just mentioned sort of the land transport road user rules. Back in the day when you had Pokemon Go and you had everyone driving around in their cars and stuff like that, you're not supposed to be using your mobile while sort of driving. So if you've got a game and you can only sort of play it properly by driving at the same time, then that's probably going to be illegal for your users. And then very quickly, it's really important to disclose all charges clearly and up front. So if you have a game and it's cost X dollars, then tell them that it's going to cost that. But if you then start charging for certain things that you can buy, like better armor or better cars, if you're like me into car games and stuff like that, then you just need to tell people that this is how much it's going to cost. And then finally, there's this concept of unfair contract terms in business to business and business to consumer contracts. Essentially, in your contracts, you can't have anything which is unfair. So taking it away from the game perspective, like I used to belong to a gym. I never go to the gym, but I signed up to, back in the day, to those 3-year, 4-year contracts where you just cannot get out of them. Those sorts of things are unfair, right? And so if you had a game and you said, well, you you're signing up to this game on Steam or whatever platform and you can't get out of it for like 4 or 5 years, that's probably going to be an unfair contract term. That would be unenforceable. So you're never going to be able to enforce that. So that's a lot of information. Feel free to email us and we'll send you a copy of the slides. Calvin and I are outside. Well, we're here today. I'm here today. Calvin's here tomorrow as well. Calvin's got a workshop tomorrow at that time. Yep. At 4 or something.
It'll be on the schedule.
It'll be on schedule. Or even just like give us a call because we're here. Free legal advice. We like free. Thank you.